Friends, in session 5 of the series on international humanitarian law, the purpose is to see and understand what is the basic concept and also the purpose or the focus of IHL as to why it is meant to be applied. The underlying doctrine of IHL can be understood if one looks at the writings of Jean Rousseau, where in 1762 he mentioned that war is in no way a relationship of man with men. And he emphasized and explained that this deals with the relationship between states because it is not the two individuals who go to war to resolve their differences, but it is two states which have problems which cannot be resolved, and recourse is taken by one, usually, or perhaps by both in some cases. Uh, and it is not, war does not take place merely by accident or comes about just by way of an accident. It is the citizens who take part in the armed conflict as soldiers, and wars usually come about by well considered design. This also needs to be borne in mind that international law, by its very nature, is supranational. It goes beyond the level of nations, it binds community of nations, the states, and the fundamental rules of international law are meant to be binding. They are meant to be observed by all states, and that is why it is international in nature. We had already seen in one of the earlier sessions that IHL is a branch of international law, which is the law of the nations. And IHL is meant to govern relations between members of the international community. By membership here, it is meant those members who are not there merely as international organizations but are member states of the world body. Of course, international organizations are also there, and they also are subject of international law. However, what is significant is that international humanitarian law comes into operation during situations of armed conflict. Care is to be taken to appreciate and note that some of the provisions of IHL, for example, training of the soldiers, that can be carried out, that is carried out during peace situations, but otherwise, by and large, IHL comes into operation, application during the war situations. With that in background, the goals, the aim of IHL would not be difficult to understand. It is meant to maintain peace, the tension, the violence, the distrust. These have no place in IHL. It is meant to maintain peace. And at the center of IHL is the protection of human beings, which would go to promote a just order, and thereby, by protecting the physical safety, security of human beings, it would go to promote social progress and freedom as opposed to unrest and chaos. Lastly, it sets legality of conduct in the armed forces, that soldiers while they may strive to attain their aim, uh, to achieve their objects, yet the conduct by the armies should be reasonable, fair, and humane. With the foregone, it should be easy to understand that International Committee of the Red Cross, ICRC, with its emblem as shown in the slide, uh, proceeds with a basic concept that the wounded, captured, or shipwrecked, they are not to be treated as enemies. This is obviously because they cannot take an active and a direct part in hostilities because of their injury, they are wounded, or they are in the custody, they have been detained as prisoners of war, and similarly, likewise, those who are shipwrecked. So, therefore, their physical condition does not afford them to be treated as enemies. They are in their situation suffering, human beings who are suffering, and they are defenseless. They need to be defended. Their security needs to be taken care of. And international law in the above situation should provide greater protection to them. Them means the three category: the wounded, captured, or shipwrecked, and the hardships of war. They should be insulated. That is the purpose or the object, basic concept of the International Committee of Red Cross. It also becomes obvious, therefore, that the overall underlying purpose of international humanitarian law is to mitigate and alleviate the suffering, the difficulties, the problems of the victims of the armed conflict, and who are in the power of the opposing force, maybe known as, maybe called as enemy, uh, whether or irrespective, due to their injuries, their sickness because they are wounded, or they are shipwrecked, or they have become prisoners of war, and lastly, the civilians who happen to be present in the theater of war to which or where the IHL is taking place. With the said background, IHL proceeds to regulate number one, treatment of persons, and these persons may be civilians, like it has been said, sick or wounded, or prisoners, or Geneva Convention 4, which deals with civilians in conflict zone, or those who are wounded or irrespective, they may be active, but then they have become prisoners. So their treatment is regulated by under various articles of IHL. It applies to the rules governing methods and means of warfare. Method means what is the way, what is the manner in which war is to be conducted, and means usually relates to the weapons, armament which is being used. IHL also regulates, more particularly, Geneva Convention number 4 uh, does in this regard the governance of occupied territory, which is the sole purpose of Article 4, and that way to protect the civilians who happen to be in the occupied territory during conflict situation, and it comes into play during conflicts, irrespective or notwithstanding that the armed conflict may not have been declared as a war by one or the other parties to the conflict. There are certain limits that have been set. Now, what are these limits? It would become clear that IHL lays down the way in which force may be used. For example, where a bullet is to be fired, or where artillery is to be used. To illustrate, an artillery should not be used, which is an area weapon against a target who is an enemy individual. So, therefore, it sets the limit to the way in which force may be used. It prohibits certain weapons, for example, poisonous gas, chemicals, weapons, or biological weapons. These are prohibited in which, as regards the manner in which war is being fought. Insists that attacks are to be directed only at military objectives. And the military objectives are those whose destruction or neutralization would affect the prosecution of war, as opposed to a civilian objective, for example, a railway line or a school or a hospital having civilians, which have no relationship to the war effort. And in that manner, indiscriminate attacks are to be avoided. They should not take place, and there should also not be any opportunities for disproportionate civilian casualties. It is to be understood in this context that there may be collateral damage, but that's quite different than what is written here, disproportionate civilian casualties that are not allowed. IHL also sets limits by enumerating persons who are hostile combat. And these hostile combat are the persons who cannot anymore take part in the armed conflict, and these are within this category included are wounded, shipwrecked, those parachuting from disabled aircrafts, prisoners of war, and civilian internees. Why is the need for IHL to set out its rules? In other words, what are the underlying causes which forced or which led to regulation of those articles and coming into force of the IHL rules, body of rules? These are listed on the slide in front of you. It happens when the rights of minorities are not observed. Now, this may be as a prelude to the war, it may be in the background to the war, but somewhere there would be a situation that would come to surface that the rights of minorities have been disregarded or thrown to the winds. Uh, Also, that while armed conflict is taking place, the human rights have been disregarded, and this has led to a necessity for IHL provisions to be enacted. Thirdly, there may be parties or at the overall situation leading the state by dictatorial regimes. Somewhere the dictatorial regime may harbor a feeling, they may observe a notion that they can do what they feel is necessary under those war situations. It is not so. That is why IHL regulates the methods and means of warfare. It may also be due to breakdown of peace within the state during war situation, prior to or during actual war situation, which may disrupt the harmony, peace in that theater of war. And lastly, this also shows in some instances crumbling governmental authority where the command or military superiority or the observance of command authority may crumble or may become weak. Why? What is the reason for application of IHL? Application of IHL was led by or came about due to devastating consequences by unbridled violence and lethal weapons. Take your mind to the Second World War, where, say, the Battle of Britain, the air bombings, the large scale displacement of civilians, devastation by the artillery and air power. Now, it is the violence, destruction led, now caused by the major forces on the two sides that led to observance and following of international humanitarian law. Another reason was that by the late 40s or mid 40s, international human rights law had come to be observed, come to be recognized, and it had taken roots. And that led to, that promoted and gave impetus to international humanitarian law. And this was also because the government came to came to observe, realize the necessity or the actual ground situation, that they had the power to choose methods and means of warfare. So a decision as to what methods and means of warfare are to be used had permeated from a lower level of the commanders higher to the governmental authority, and this order, establishment of law and order, was within the grasp of the governmental authority, and it was no more a situation that in war there was absolute chaos and disorder. The governments could retain an authority, and that led to international humanitarian law principles being evolved. Now, how does IHL carry out its mission? It has decided, and at the center of IHL activities is the protection that needs to be given, that is required by the persons who are not taking part in armed conflict, uh, from the consequences of war. Now, consequences of war may require total war efforts. They may require stringent economic measures. Now, these two examples should be viewed having regard, say, to the provisions of Geneva Convention 3, which lays down the bottom line as regards authorization of prisoners. So, therefore, the consequences of war, notwithstanding, protection is to be given to the persons who are at the focus of IHL. The other aspect is that IHL comes into operation during war situation, should not lead one to infer that the role of IHL is inconsistent with general prohibition of war. And by that, I am referring to the Universal Declaration of Human Rights, where the prosecution of war has been disfavored. Now, just because the IHL has come in existence by the evolution of Geneva Convention does not mean that a free hand has been given and the war is no longer prohibited. The war continues to be prohibited. However, if and when it has to take place, IHL provisions will straight away come into operation. And IHL would become application whenever an armed conflict actually breaks out. IHL does not concern itself with the reason for that war. The other important point to be understood is that notwithstanding the presence of Geneva Conventions or additional protocols or the instruments, say, relating to anti-personnel mine, which the body of nations collectively has debated, discussed, and then enacted. There is also customary IHL, which gets evolved, which gets fine-tuned by the practice which is followed by the group of nations, by the community of nations, and that is how it develops um, through also through the adoption of treaties and the this part which is known as formation of customary rules of international humanitarian law. It is also to be borne in mind as to what the IHL does not do. IHL by and large does not regulate a state's treatment of its own citizens. So those states which are taking part in armed conflict are free. It is within their sovereignty to deal with its own citizens. And illustration has been given that if country A is at a war with country B and a citizen of country A decides for some reasons to go and enlist oneself in the army of B, then he is not entitled to PW status because he has himself decided to go and join the armed forces of the enemy country. If that has happened, even if he is captured, he would not be given, not be accorded PW status. At the same time, uh, some provisions of IHL do apply to the relationship between a state and its own citizens. This is an exception. An example is also there on the slide in front of you under the Geneva Conventions and Additional Protocol 1. A state is required to take positive steps in relation to its own citizens and say, for example, with regard to dissemination of IHL. Now, during peacetime, a state is required to undertake proper teaching and dissemination of IHL provisions to its soldiers or in its to its general public. Now, to that extent, IHL does take into consideration the relationship between a state and its own citizens. What is the acceptance and where does the IHL stand with regard to recognition by the community of nations? Well, more than 175 states have already ratified and accepted Geneva Conventions. There are only very few exceptions of the situation where countries have not, and the six different colors that you see used at the bottom of this slide indicates the situation, the cumulative effect with regard to the IHL instruments. In the end, it would need to be appreciated by you that the true test of IHL would lie in a situation where the combatants and those who command them means the power of authority being wielded by the commanders, whether they abide by the rules. Well, if the soldiers and their commanders respect the rules and follow and practice them, IHL is successful. The IHL has attained its aim. Ultimately, in the final analysis, what is needed beyond humanitarian original actions, it is the political will of the states to spare civilians and those who are not in a position to fight anymore and thereby show their respect for the international humanitarian law. Thank you.